We are ready to get started for our 4 o'clock panel. Hi, everybody. It's good to be with you. My name is Matthew Sanderson. I'm a partner at Kaplan & Drysdale, specializing in election law. We are joined on this panel today by Teresa Gavarone of Ohio and Senator Chris Lee of Hawaii. We are talking today about foreign influence in state politics. And this has become a news item yet again in the last couple of weeks, and it seems like we've been talking about this topic overall in the public discourse for over a decade. But this subject of foreign influence has actually been with us since the founding of our country. The framers were very interested in this topic and very wary of foreign influence over the process of our politics. So much so that they enacted the Emoluments Clause that prohibited any person holding an office or profit or trust from accepting any emolument, office, title, or title from any king, prince, or foreign state. They put in place the Natural Born Citizen Clause that limited eligibility for president, and the impeachment power was at least partially motivated by a worry about foreign influence over politics in the United States. At the same time, we have a very prominent part of our constitutional framework. The First Amendment says that Congress shall make no law abridging the freedom of speech or of the press or the right of the people to assemble and to petition the government for redress of grievances. So one of the things that makes this an interesting topic is that we have had a perpetual worry about foreign influence over our governance process, over our elections. At the same time, we have a very open system that prizes speech, that prizes discourse, that prizes participation and viewpoints from every corner. So, given our commitment to an open system, what is the proper role of foreign nationals in elections, discourse about elections and governmental actions? So that's what we're here to talk about today. I'm going to give a short overview of the federal law, and then we will dive in particular into the laws in Hawaii and Ohio as illustrations of the issues that come up in this area. But before we get to that, we are going to, NCSL has been driving interactivity in its panels, and so we're wanting to open up with a question. And so if you could look at this slide, and then turn to your neighbor, discuss the topic for a minute or two, and then we'll come back. So the question at issue here is: a green card holder, a lawful permanent resident, contributes to a U.S. Senate candidate's campaign. Is this legal? Should it be restricted, or should it not be restricted? So, talk amongst yourselves. Okay. All right. Hopefully you had an enlightening discussion in that 1 to 2 minutes. It is an interesting topic, though, right? It's an interesting question. And I can at least answer, just to kind of kick us off here, I can at least say that as a matter, the correct answer to the question is yes, it is legal, at least as to a U.S. Senate candidate. So federal law permits lawfully permanent residents, green card holders, to contribute to federal level candidates. Now, the second part of the question is what we're going to get into a little bit more, which is at the state level, should it be legal? And there are a variety of opinions on that and a variety of approaches that states have taken. But before we get to that, let's talk about the federal overlay, because this applies, this federal foreign national ban, let's call it, it applies to federal, state, and local elections. It has been with us in one form or fashion since 1966. So in 1966, Congress enacted a law that barred foreign governments and foreign government representatives from contributing to election campaigns. In 1974, they enacted a ban as part of a comprehensive campaign finance legislation, enacted a ban on all foreign nationals from making contributions and expenditures about candidates. And then in the early 2000s, as part of the McCain-Feingold Act, the Congress enacted a law that extended the ban on foreign nationals to political parties. So this is actually a relatively recent, even though this worry about foreign influence has been with us for some time, at least at the federal level, it's a relatively recent development, 1966, 1974, 2003. So the contours of that are interesting, and I think the reason why we're starting with this, it kind of sets the table for the state level legislation that we see. And the overlay of federal law says that a foreign national may not do any of the following in federal, state, or local elections. It's very broadly defined as in terms of the activity that is restricted. There's a ban on contributions, on expenditures, and then in case something falls outside those terms of art under federal law, those have a very particular meaning. The ban is broadened to include not only contributions, but donations, and not only expenditures, but disbursements. The ban also extends to directing election spending and participating in decision-making about election spending. So this all begs the question, who's a foreign national under federal law? A foreign national is any individual who is not a U.S. citizen or lawful permanent resident, okay? So anyone who's not a green card holder or a U.S. citizen. And then any foreign government, political party, corporation, or organization or group. So any entity that is headquartered outside the United States, that would be a foreign national for these purposes. With that, there are a couple of interesting features to federal law. One is that it does allow foreign nationals to do things like volunteer. So foreign nationals can hand out leaflets, they can do all the types of things that you would see in a regular campaign other than make decisions about an ad buy or go out and fundraise or contribute themselves. So that's a carve out. The other carve out that's very important, at least when we get to the state level, is it does not extend to contributions for the purpose of supporting or opposing a ballot measure at the state level. So it does not extend to that. There are a couple of, before we turn to the state law, though, there are a couple of things just also worth noting about the federal ban. One is that at least at the federal level, domestic subsidiaries of foreign corporations are treated as domestic actors, formalistically. So if there is a domestic corporation, even if it's wholly owned by a foreign corporation, as long as it's separately incorporated, and as long as the donation comes from domestically derived business activities, and as long as U.S. citizens or green card holders direct the funds, a domestic subsidiary, even a wholly owned subsidiary of a foreign corporation, can make a contribution or expenditure or do any of these things we talked about that are otherwise banned under federal law. I note that because there are some differences of approaches when we get to the state level. The other question that comes up is, what about super PACs? Okay, so they're a relatively new wrinkle in elections. They're a relatively new wrinkle at the federal level as well. They've been with us since 2010. Well, somebody challenged this. It's a case called Blumen. I think there are handouts available outside or at the back. I'm somewhere back there. By the way, if you're looking for CLE credit, I forgot to mention this at the front end, but I'm going to mention it now. If you're looking for CLE credit, there is a sign-in sheet at the table just outside. So after Citizens United and Speech Now, which are two court cases, created super PACs at the federal level, there was a challenge on whether the ban could apply to super PACs. And what the DC District Court, which was later summarily affirmed by the Supreme Court of the United States, said was that these foreign nationals, these Canadian nationals that were planning to contribute to candidates, to print flyers at their own expense, and to give to outside groups, that they were prohibited from doing so. And there are a couple interesting quotes in there that I think inform our discussion overall. One is that the court said, First Amendment issues raised by campaign finance laws have been the subject of great debates. This case does not implicate those debates. In other words, the court held that foreign nationals really had no First Amendment rights. They had no free speech rights, at least in terms of spending money. Now, as we see this play out nationally, there's not only the federal law, there's not only the federal national ban, but there are state-level bans. In 38 states, and we have the pleasure of having two leaders from two of those states here, there are bans on foreign nationals making contributions. So of the 38 states, 33 of the states ban contributions to ballot measures. There are a variety of approaches to foreign corporations and domestic subsidiaries of foreign corporations, and we'll get into that in just a moment. And there have been a lot of litigation on this topic. So let's do one more another interactive session, and then we'll talk to State Senator Gavarone and State Senator Lee. One of the main issues that comes up for state-level bans is that how domestic subsidiaries of foreign corporations are treated for purposes of this ban. So take a shot at it, okay? Let's say you have a hypothetical foreign corporation, or a U.S. corporation, excuse me, that is 10% owned by foreign nationals, by individuals or corporations that are located outside the United States. Should that business be allowed to make a contribution to a candidate or a ballot measure? Discuss amongst yourselves. Okay. All right. So one of the interesting things about state laws here is that they do take a variety of approaches. So Colorado, for example, bans LLCs if a foreign individual is even just a limited member of an LLC. Nebraska, on the other hand, takes a similar approach to the federal law, meaning that if it's a domestic corporation, as long as it's separately funded and as long as U.S. citizens are making decisions about ballot measure contributions and political contributions, then it is permissible. So a variety of approaches, and we're going to talk specifically about two very prominent pieces of legislation that were considered recently in the state of Ohio and in the state of Hawaii. So Senator Gabaron, let's start with you if we could. So you came, what got you interested in this legislation?
Thank you. Well, first I'll say that Ohio passed House Bill 1A last General Assembly, and what it did was it expanded the definition of foreign nationals to include green card holders, the lawful permanent residents. And then it also expanded prohibitions to include ballot initiatives on top of contributions to candidates. So I got interested when I learned about a Swiss billionaire who had been donating millions of dollars to some ballot initiatives that were geared at changing Ohio's constitution. And it makes you wonder, why would a Swiss billionaire who doesn't want to become an American citizen want to change Ohio's constitution? It certainly makes you scratch your head. And then I did a little more digging, and I found out about this dark web of money flowing through the 1630 Fund and Arabella Advisors. And then hearing more. There's a biography written on this Swiss billionaire where his sister is quoted as saying that he wants to reinterpret the United States Constitution in light of progressive politics, but yet he doesn't want to become an American citizen. So all of that really makes you wonder why someone would try to change state constitutions across our country. And it certainly doesn't seem right. I mean, there are a lot of bad actors out there who don't like America, don't like our way of life, and want to change us. And that's what got me interested in diving into this issue and looking at ways to protect our Constitution, to make sure that our citizens are hearing from Ohioans, from Americans, when they are learning about these ballot initiatives as well as candidates. So I think it's important legislation. I think we need to continue to be vigilant when it comes to this subject.
So Senator Lee, tell us about your bill. What approach does it take?
Yeah, so the bill that we've considered in Hawaii, which we've considered for a couple of years running now, was based on a series of circumstances that have transpired over the last really decade or so. I've been really fortunate to serve in the state legislature in the House and the Senate. I have equal appreciation for both of them for the last 18 years. And in that time, I'm going to try and leave off the company names, which is probably the sexy part everyone's going to want to know, but maybe we'll come back to that in Q&A. But basically, there was an issue in one of our counties some years ago, I think 2014-ish, that led to a big vote during an election. And some of the companies that were engaged in that poured in tens of millions of dollars into things leading up to this. There were $8 million directly spent on campaigning in that particular election on this one topic. And at the end of the day, it ended up being one of the most expensive races in the history of the United States per capita, which was estimated to have spent between $75 to $90 per voter on trying to influence outcomes. The second thing, which came up in about 2015 or so, was a utility that was, or outside of Hawaii utility that was looking to buy and acquire some of our local utilities. And I bring that up because the campaign that was launched through that process had that outside company spending about $26 million or thereabouts on advertising and full 18-month campaign to try and convince convince voters that this was the right thing to do. And that's relevant now because while that was an American company, there's another foreign company that's been looking just this past year at either acquiring a significant interest in our utilities or acquiring assets or something thereabouts. And obviously, there's a lot of concern over what influence that has when those entities ultimately set the rates that we all pay as local residents and what that means. The last thing that's come up just in the last few years has been a significant number of our colleagues who've been concerned about foreign actors and entities acquiring land in Hawaii. And if there's one thing we're short on in Hawaii, it's land. So that stuff comes at a premium, and what happens to it and who controls that is near and dear to a lot of people's hearts. So there were a number of things that led to two bills, one of which was focused on land, one of which was focused on campaign contributions. And to get to the start of your question, because I'm not going to dodge it entirely, even though we have the skill set in this room to do that repeatedly, the bill that we had put forward basically tried to close a loophole that you had highlighted, which would allow corporations or entities that are foreign influenced or have a share of ownership by foreign entities from contributing to the process and influencing things. And we can get in the weeds on that in a bit, but in general, that was the intent, to really try and draw the line somewhere to say that even though you're an outside company coming in, you want to play ball here, that's great, but you can't influence the outcome of that, influence campaigns, influence the legislature and other entities while trying to do that.
Yeah. So, Senator Gavarone, one of the things that's come up in Ohio has been the status of lawfully permanent residents, so green card holders. Some states bar green card holders. The federal level ban, as we just talked about, does not. How do you think about that? What should lawfully permanent residents be on par with the rights of U.S. citizens? Should they have rights on par with those of U.S. citizens? Should they be different? What are your thoughts on that?
Well, in Ohio, in 2022, Ohio voters passed a constitutional amendment that said only U.S. citizens and nationals can vote in our elections. So taking that as a starting point, it only makes sense. If you can't influence our elections by voting in them, then you shouldn't be able to influence our elections by contributing to them. So that was how we formulated that part of that legislation.
Got it. So I guess, Senator Lee, on your side with Hawaii, one of the major features of your bill is, as we talked about, there are different approaches to how a state might view a corporation that has some foreign ownership. Your bill sets it at a relatively low level, so 1%, if I'm not mistaken. 1% threshold of foreign ownership subjects that corporation to a ban. Why is 1% the right answer? What concerns do you have there with something that's minority owned by a foreign person?
Yeah, so 1% sounds like a tiny amount, but in practice, what we've seen is in especially large, multinational, kind of overwhelmingly large companies, your typical stakes in ownership are tiny, and having a 1% ownership is actually quite large. It can get you a board seat, it can get you influence in all sorts of ways. And so if you're going to have influence driving a company to get involved in something or to put its money into a campaign of some sort or whatever it is, that's relatively easy to do. And so it's a practical consideration. That being said, one of the things that we looked at also was in what ways can companies influence the process? Like, where are they sticking this money? As we had mentioned, right now, federal law prohibits foreign contributions directly to candidates from foreign individuals. So the distinction in the law, or the proposed law anyway, which changed and had a bunch of variations as these things do, so I'll talk about this kind of generally, was that there's no prohibition on an individual from giving. In other words, if you're an officer in a company or an employee or whomever it is, you're able to contribute just as everyone else, exercising your full constitutional rights to speech or whatever it is. You can still do that. What it would disallow is the capacity of a corporation and the usually tens or hundreds or billions of dollars that it has from being directed as a tool into super PAC, for example, to then be used in an attack campaign against a particular candidate or something like that. So it really, in practice, directed a lot of the resources of people who would, at the company, be engaged to the campaigns of candidates themselves, rather than to roundabout kind of dark money channels to go launch campaigns against whomever on either side of the aisle on whatever issue there might be.
So a question for both of you, I guess, is, I just mentioned there are 38 states overall that have some sort of foreign national ban. And the two of you are on this stage, one of you is a Republican, one of you is a Democrat. What do you think it is about this issue that tends to lead to bipartisan consensus in a number of different jurisdictions?
Well, really, it shouldn't be a red issue or a blue issue, Democrat or Republican. I mean, it's really an American issue. When we have people from other countries who want to come and influence our elections and maybe change our constitutions or elect certain people, it certainly, it makes you wonder what their motives might be. And so I think it's something that we can all agree that we want to protect the system our founding fathers put in place almost 250 years ago. And it's an American issue.
Senator Lee, anything to add?
I agree 100%. I think as we all ran for office hoping for the best for this country, for the communities we come from. I've never met another elected official who intentionally went through the hellscape that it is trying to raise money and get out there and go door to door and do all the town halls and get all the arrows, with ill intent. And I think that's where all the other partisan stuff aside, we fundamentally, I think, agree overwhelmingly that the control of our country, the control of our states, the control of our local communities belongs in the hands of those of us who live here in those communities. That's not to say that there aren't considerations to be made for everybody else who's coming in and that whole process, and we'll let that debate happen in DC at the moment. But when it comes to the fundamental influence in campaigns and the money being spent, the value that those folks in our communities have, the interest they have in that outcome ought to be upheld. And I think that's something that will dictate not only outcomes today, but potentially for generations to come with some of the decisions that we have to make right now here at this time.
So I think it's interesting, each of you have come at this from a different angle. You're in two very different states. But I hear, in your talking about the importance of each of your legislation, you're talking about the importance of local control over political processes or decision making. Do you think that, so it's a justification of basically being able to define your political community. If we kind of unpack that a little bit further, do you think that these prohibitions on foreign nationals could be applied to individuals and groups that don't reside in each of your respective states? In other words, could there be special contribution limits or bans on non-resident contributions, and would you support that? I know Hawaii has experience with that, but either of you, any views on that?
Well, the Supreme Court grants broad First Amendment, the highest First Amendment rights to its citizens here in the United States, and that allows people to participate across state lines. And it's really, I think, because Americans have an allegiance to America, but there are broad First Amendment rights for U.S. citizens.
Right now in the books, Hawaii has a law that's been around actually since before my time that says as a candidate, you can't accept more than 30% of your total aggregate campaign donations from people or entities that are out of state. So if I get a $1 billion check from Utah, I'd have to raise that times a multiplier in Hawaii, which really limits that influence. But the real concern is not so much, at least for us anyway, for me, is not so much the direct dollars that individual candidates or elected officials are raising, because we have pretty strict campaign finance laws with caps and everything else. So we're all kind of playing by the same set of rules. But it is the outside influence coming in with millions and millions of dollars, which is basically unrestricted, that is influencing the broader process. And when we have folks coming in to buy land or buy out our local companies and really exercise a huge amount of control of our communities around our elected officials, that's a problem. And just to give you an example, one of those companies right now that was involved in one of the earlier elections that was like crazy expensive that I mentioned, is today a wholly Chinese subsidiary owned company. And it may be totally innocuous and completely nothing to worry about, or it could be something that actually presents a real concern. But that also disenfranchises our local population, our local communities, when they're spending tens of millions of dollars trying to run roughshod over what the actual will of a community is, especially if it's spreading misinformation or any number of other things that we all are experiencing across the country right now.
So I want to switch gears here for a second. We've spent a lot of time talking about foreign election advocacy, but I want to talk a little bit about foreign lobbying. In other words, policy advocacy, so foreign influence over governmental actions. And we have an interesting, kind of similar legal regime in place. But before we get to that, we have another interactive moment. So let's talk about that for a second. So the prompt question is: a U.S. citizen is persuading legislators to change foreign contribution laws on behalf of a foreign government. Should this person disclose their relationship with the foreign government? Talk amongst yourselves. Any no's out there? Yeah, probably not, yeah. Okay, so that's probably a pretty easy answer at most tables. The correct answer, whether you should or should not, the fact is you probably do have to disclose, given federal law. There is a broad and quite old federal law called the Foreign Agents Registration Act. And so we'll talk a little bit about this before we get to the state level approaches here. The Foreign Agents Registration Act was enacted by Congress in 1938 in the run-up to World War II as a way to combat Nazi and Soviet propaganda efforts. The picture on the slide here is from Madison Square Garden in the 1930s. If you look closely, you will see George Washington ringed with American flags and swastikas. This is an event held at Madison Square Garden by the German-American Bund, which was one of the groups that was required to register. There's a good documentary, short 7-minute documentary on that night called The Night at the Garden, if you get a chance to look at it. So this law has been with us since 1938. Its enforcement has ebbed and flowed over time. It is strategically vague, I would say, so that it allows federal prosecutors to come behind the law and police actions that the prosecutors don't like. The main, if we were to boil it down, just to give you the landscape here, the basic concept is that if someone becomes an agent of a foreign principal, they're required to register unless an exemption applies. Because this is, the reason I mentioned the original intent of this law is to catch Nazi and Soviet propagandists, the reason I mention that is because it starts exactly where you might think. It bears all the hallmarks of that original intent in that it starts from a very broad place. And as I mentioned, is vague, and it basically means that the key definitions there are a foreign principal, which can include a foreign government or foreign political party, as you might expect, but also includes foreign corporations, foreign NGOs, foreign individuals, and even U.S. citizens who are domiciled outside the United States. So it starts from a very broad place. That breadth continues with the definition, key definition of agent. It's anyone engaging in registrable activity within the United States at the order, direction, control, or request of a foreign principal. What are registrable activities? Well, mostly it's efforts to influence U.S. policy and U.S. public opinion. So if you're trying to influence U.S. policy and public opinion on behalf of a foreign corporation, foreign NGO, foreign individual, foreign government, foreign political party, registration is required unless there's an exemption that applies. And there are a number of different exemptions. The important ones at the federal level for the Foreign Agents Registration Act are those who are engaged only in bona fide trade or commerce, so trying to buy and sell widgets or services. Persons who are registered under the Lobbying Disclosure Act, which is the federal level domestic lobbying disclosure act. Persons engaged only in activities that further the fine arts, or there's a typo there, bona fide religious, scholastic, academic, or scientific pursuits. And the last one, which ends up being very important, but we don't have time to get into, they wrote it in 1938, so it does not lend itself to an acronym, and it is a bit of a mouthful. Persons engaged in activities not serving predominantly a foreign interest. So the way to think about this is the way that FARA works, the Foreign Agents Registration works, is those who are working on behalf of foreign governments and foreign political parties have very narrow exceptions and most likely have to register. Those who are working on behalf of foreign corporations or foreign NGOs have broad exemptions and most likely do not need to register. So that's the way I synthesize the Foreign Agents Registration Act. That is the federal overlay for how the states are starting to deal with foreign agents issues. As Senator Lee mentioned, there's quite a lot of attention around purchases of real estate by foreign interests, as well as prohibitions on colleges and universities accepting funds from certain sources. That's the overall context. The states have, relatively recently, feds have been at this since 1938, states have been at this more recently. There are now 6 states that have their own foreign agents laws: Arkansas, Florida, Louisiana, Nebraska, Texas, and Utah. Those laws tend to focus on direct lobbying, whereas the federal level law, FARA, applies to even PR campaigns and broader efforts that don't involve any direct lobbying communications. And it also tends to focus more on agents of certain foreign governments, adversarial governments like China, Russia, Iran, etc., rather than all types of foreign interests. There are some exceptions. Arkansas enacted a law just this last year that will go into full effect in January 2026 that would subject entities that simply receive money from adversarial governments or corporations located in those countries or individuals who are citizens of those countries to specially register at the state level. So there are a variety of approaches, but so far there are only 6 states taking a look at this. So I want to get back to talking with our 2 state senators here. Neither of your states have a foreign agent law, but do you see this as an issue? What do you think about foreign lobbying?
Well, lobbying is important. As a legislator, it's important that you're understanding every aspect of a piece of legislation that you're considering. And I think transparency is key. There's federal registration that you have to disclose if you have that foreign relationship. But in Ohio, our registration doesn't differentiate between domestic and foreign lobbyists. Everything is very thorough, and our form is thorough across the board. But as a legislator, as we move to more global interests, and you see the interconnectivity, I think it's important that you're hearing from people. And just because you are hearing from a foreign lobbyist, that doesn't end your investigation into an issue or a topic. You need to continue. It's important to hear that perspective, but it's also important to continue working on legislation and continue doing your homework and research when you're considering any piece of legislation.
I'll chime in and say, it's interesting because this goes back to the interesting nature of this issue being something that both Republican and Democratic, liberal and conservative states kind of all have a shared interest in different degrees. In Hawaii, we're fairly democratic, right? We're a blue state. We also are a state of immigrants. I mean, like 85% plus of our population have immigrated from other places, other countries. So the one thing that we're trying not to do on our end is create a xenophobia or stereotype or tie this into other issues that are going on right now. And the other thing is that we realized in our existing land ownership, we already have a number of foreign investors / owners, mostly Canada and other allied countries and friendly countries. And so our ag sector actually raised some concerns about prohibitions on land acquisition in those cases. And the one thing we don't want to do at the same time is really discount and diminish or prevent investment in the state when it comes through partnerships and other things with other foreign entities. But that said, because of those issues, we chose to focus on the campaign finance, business, corporate side of things. How do we ensure that we have some restrictions in place that bar those companies that have an influence, a meaningful foreign influence, from being able to use the resources of those companies to funnel tens of millions of dollars or other things into the process around the spirit and intent, I think, of the federal laws that currently exist that prohibit direct contributions to candidates and other things like that. So there is this discussion that's going on, trying to figure out, all right, how do we thread that needle and what does that look like? But by and large, we're trying to maintain who we are and the investment that we want, while at the same time making sure that we're going to have some level of control over the amounts of money coming into our process. Because we're a small state. We're like 1.4 million people, and our elections are very cheap overall. So when a company or a super PAC can dump even $100,000 or a couple $100,000, much less millions or tens of millions into it, it can have a serious impact. So that's really, I think, where we're trying to focus right now. And we think that will actually have a bigger impact. Well, I think that would have a bigger impact for the time put in, at least right here and now.
So we've talked about both election advocacy, foreign election advocacy, and foreign policy advocacy. We've discussed the federal level rules as well as the variety of state level rules. In each of these areas, both election advocacy and policy advocacy, there's a division of labor between the federal government and the state governments. What do you think the ideal balance is there?
Well, elections, that's been a core function of the states. And I think that it's important that states have significant control over their elections within the federal framework. So, and a state should be able to be a little more stringent if that's what they decide to do, as long as they're acting, appropriately and within their state constitution and the U.S. Constitution.
States' rights, baby. That's great. Put that on a campaign poster. Nice. So one of the concerns that has been raised over time when we're talking about foreign lobbying disclosures is that there have been, FARA at the federal level has gained more prominence, and then states are starting to pay attention to this issue a little bit more. Those laws have, in some sense, been copied and pasted by developing countries outside the U.S. So the country of Georgia, for example, very prominently copied and pasted the U.S. Foreign Agents Registration Act. And one of the criticisms and one of the concerns that has been voiced is that that's been used as a way to combat civil society in those countries. Do you all have that same concern here, that it could be used to combat civil society, number one, and number two, do you have any concerns about it being exported to developing countries, the U.S. FARA laws or foreign agents laws being used by developing democracies?
Well, in the United States, we have a strong, democratic institution in place, and what works for us here may not necessarily work in newly developing countries. But certainly, if a country thinks that something we're doing here could serve as a blueprint or a starting point, I don't see anything wrong with that, as long as the country is looking to us and making sure that they have proper safeguards in place and what they're doing is right for their citizens.
Okay. Yeah, no, I think that's one of the concerns, is that some of these developing democracies don't have that same infrastructure, but certainly it's been a feature of our democracy since 1938. So obviously it can be managed in some form or fashion. We are to the point of Q&A. So we'll open it up for questions. I think they've asked that people come to the microphones so that everybody can hear, including on the live stream. So if you wouldn't mind. Thank you.
Good afternoon. My name is Michael Chernick. I'm on the legal staff in Vermont, the nonpartisan legal staff. And I'm curious, this is directed to the member from Hawaii. You indicated there is a Hawaii statute limiting the percentage of campaign funds that may originate from out of state. Back in the 1990s, Vermont tried that as part of a massive campaign finance law, much of which was eventually shot down by the Supreme Court. And one of the elements, it was the case was the Sorrell case, who was then our Attorney General. He was the defendant, and one of the elements was a limitation on the percentage of contributions. I think it might have been 75%, but whatever, that's not the key point. The key point is that there was an element of out-of-state limitation. Again, by U.S. citizens or U.S. corporations. We're not speaking about foreign contributions whatsoever. And the court shot it down, saying there was a First Amendment right and that it could not be upheld. So I was curious and wondering that if the Hawaii statute's ever been challenged in federal court. Thank you.
I believe, and I'm sure if there's attorneys from Hawaii in the room, I don't know that there are, but I believe the case has been litigated, or that provision's been litigated. And again, the provision basically says, as a candidate, you can't in the aggregate receive more than 30% of your total campaign funds in one cycle from out of state. And that has been, or it's been around a long, long time. And I believe it's been litigated and obviously upheld if that's the case. But I couldn't tell you the particulars of why.
Hi, thank you. I'm Senator Jim Roosevelt from Maryland, and I was, a couple of decades ago, the U.S. ambassador to Romania. and follow pretty closely what's going on in that part of the world. And we all know about the Russian and Ukrainian oligarch attempted interference in the 2016 election. We know, probably most people here, I'm sure some people here know, but most Americans don't know about the Russian intervention in the Romanian presidential election in May, where huge amounts of money were put in illegally to try to affect the election. So this legal stuff is interesting to me, but I'm actually more interested in, are states doing anything to try to deal with the illegal intervention of China, Russia, Iran in our political process? I'm definitely aware of it. Well, maybe they're not aware of it. Okay. Are you aware of the fact that China and Russia, Iran I know no less about, are trying to interfere not just with our elections, but with our whole political process?
Yes, is the short answer. There's been a number of stories,
Yeah.
I think, on, I don't want to call out the state in particular, but there was one that was excoriated quite at length in a series of articles, maybe about like 6 or 8 months ago. And we know that presence is there and that influence, but trying to track exactly how that's going, I think I don't know that anybody has a solid handle on exactly a full picture of that, at least that I'm aware of or I've ever seen.
And I think that's why legislation is important, to make sure that that states, at least Ohio, thinks it's very important to make sure that we are preventing contributions to candidates, to campaigns from non-citizens.
But
or
why would they obey the law?
non-nationals.
Why would the Chinese or the Russians obey the law?
Pardon me?
Why would the Russians or Chinese obey the law?
Well, it's important that we are vigilant. I mean, the
I
states
agree.
need
That's
to be.
that's the question I'm asking.
Yeah, the states need to be vigilant. We pass laws. Actually, that House Bill 1A that I've been referring to is kind of held up in litigation right now. That hasn't been finalized yet. But it's important that states are doing what they can to make laws and, as they're passed, to enforce those laws.
I agree with that.
Yeah, I'll just chime in and say, in our case, we have existing laws, obviously, with penalties for violating campaign spending law and all
Right.
that kind of thing. On the magnitude of money that could come in and be spent, or has in some cases, I mean, those penalties are, a pittance. It's like a slap on the wrist.
Yep.
And overall, tracking that stuff is extremely hard in the first place to have a case to effectively prosecute and be able to track. So to your point, I'm sure it's happening in various places. We probably don't see it all. And even when we do see it, there's limited tools available. I think what we were trying to do in Hawaii is make sure that you can stop something from happening that we're starting to see more and more, where you have a company or a foreign interest that wants to do something. They want to come in and buy up some land or sell a product or build a whatever. And if they get opposition from a couple council candidates in the local government or at the state level for whatever reason, they can set up a shell company, route a ton of money through that into a super PAC, and then do attack ads on those specific elected officials, get them out of office, come back again for round 2. I think that's really where we're trying to cut things off. And while we don't have, I think, a perfect solution, even if we put the stuff in place right now that says, you got to have like some line where if you're a foreign company that you're going to be barred from doing that, we do need stronger penalties in addition to that. And I think to be able to track that and have some sort of meaningful action on it, you need the staffing, you need the resources, you need all those things. So this is by no means, at least our proposal is by no means a silver bullet.
Sure.
But it would certainly cut off one legal pathway that's currently legal right now to easily just go attack whoever you want.
And I'll just add, I think, you see a lot of legislative energy around passing laws, around investigating these issues by the legislative branch, but also at the federal, state, and local level. I think there's a unprecedented push over the past 5 years to investigate and prosecute efforts to influence elections or policy actions, failure to register under FARA, for example. Up until this year, there had been a multi-agency foreign influence task force at the federal level that worked closely with state and local authorities as well. I don't know what the next iteration of that will be, but the issue is not going away, and I would expect that prosecutors at the federal, state, and local level will have elevated and enhanced attention to this issue.
If I just may follow up, I didn't know that actually. So there has been state involvement with the federal efforts over the past 4 or 5 years.
Yes, yeah,
Gotcha. I think it's important, that's all I'm going to say. Thanks.
agreed. Any other questions? I had just one more, if I could. It's not a softball, unfortunately, but I think it's an interesting issue to think about, which is, so we started the discussion by talking about the juxtaposition of our very open system and how foreigners are treated separately, treated differently than U.S. actors. But I guess, as we think about this, the right to vote has never been a precondition for the right to speak. And the Supreme Court has said, what matters is speech, not the speakers. So what if, do you have any concerns from a public discourse standpoint, from a free speech standpoint, about bans on foreign participation in election advocacy? And if so, how do you adjust for those types of concerns that might affect the messages that Americans hear?
Well, I think the Supreme Court got it wrong. I think we all, as individuals, should have a right to vote and participate and speak and all those things. I don't think that means a corporation of itself ought to have those exact same rights. Right? There's any number of officers, employees, investors in a corporation that all have those same rights to go speak and say, you know what, we like policies that do X, Y, and Z, it's going to benefit our business or whatever. But the corporation itself as an entity, that's a different question. So I approach it from that. I recognize the Supreme Court has, obviously said this in over the last couple decade and a half or so. But we still have a responsibility to have a practical, pragmatic process that has an outcome that benefits our citizens and our community. And that means, I think, as we go through this process right now, where laws are changing, interpretations are changing, everything's changing, we have, I think, an obligation to push the envelope and see how much we can get done. And if we're going to run into a barrier, we run into a barrier, so be it. We'll find another way. But I think not trying is giving up right off the bat.
Senator Gavarone, anything to add?
Yeah, well, foreign nationals don't have the same First Amendment rights as American citizens do. And, as such, for years, foreign nationals have not been able to participate and contribute to candidate campaigns. And there's a reason for that. Money can influence. You see how many billions of dollars get poured into elections to influence the outcome. So I think it is important that we are paying attention to who is contributing to these campaigns and who is trying to really manipulate or influence our elections. And it should be American citizens and nationals.
I think we are at time. Please join me in thanking our panelists.